Hi, I'm Manny Fitzsimmons. I'm your Washington Realtors Legal Hotline lawyer, and this video is another in our series entitled Real Estate Fundamentals You Should Know. And today we're going to talk about Form 22T, the Title Review Contingency. The Title Review Contingency is a document that's an addendum that is supplemental to the Form 21 Purchase and Sale Agreement. The Form 21 Purchase and Sale Agreement requires seller to deliver title in marketable condition. If seller can't deliver marketable title, then seller can't perform the terms required of seller using just the basic Form 21 Purchase and Sale Agreement. So the Form 22, the Title Review Form 22T, the Title Review Contingency, is supplemental to that requirement for marketable title. So what more is required with the addition of Form 22T? With the Form 22T, buyer has the opportunity to review the preliminary commitment for title, and that right to review can start either from the date of mutual acceptance or from the date that a subsequent preliminary commitment for title is delivered to buyer, and that would typically be the title that's pulled based on this purchase and sale agreement that would show buyer's name and any conditions related to buyer that show up on title. So buyer has, by default, if you use a default number of days, 5 days to review the title report and to identify for seller conditions on title objectionable to buyer. Now, we already know that title has to be marketable, so the conditions to which buyer will be objecting are not likely conditions that make title unmarketable. Instead, they're conditions that are marketable conditions on title, but conditions that make the property unsuitable for buyer's intended purposes. For example, let's say that buyer wants to put a swimming pool in the backyard, and the preliminary commitment for title reveals that there's a sewer line, easement, serving a neighbor, running through buyer's backyard. That sewer line easement doesn't make the title unmarketable, but it would certainly make the property unusable for a swimming pool in the backyard. Let's say that there are a set of CC&Rs recorded against title of the property. Certainly, that does not make title unmarketable. But if this buyer is purchasing the property for the purpose of operating an in-home daycare out of the home, and it turns out that the CC&Rs prohibit in-home businesses in the residence, then the condition on title would make the property unusable for buyer's intended purposes. In either of those circumstances, buyer would ask seller to remove the condition. This is how the title contingency is written. Buyer would ask seller to remove those conditions, and in both circumstances, seller would have no ability to remove those conditions, and so buyer would then have the option of terminating the purchase and sale agreement. That's why you would use 22T. You would add 22T to a transaction if there is some, I would describe it maybe some unique purpose for which buyer wants to make of seller's property. If all that buyer needs is marketable title and buyer's not going to do anything special with the property, chances are buyer doesn't need a 22T in the transaction. Lots of brokers include a 22T just so that buyer has that opportunity to review title and terminate on that basis if something does occur to buyer as unwanted on their title. I'm not going to fix my hair. I want to make sure you understand, though, what the 22T does not do, because this is important. If you have a buyer who, for example, has a beautiful view from their property, and they want to make sure that the view is preserved and that the people who own the property in front of their property can't build on it. And seller has said, no worries, I've got a view easement across the property that lies between me and the view, so your view will never be obstructed. And buyer says, excellent, I'd like to see that view easement before I purchase. Buyer brokers do not include a 22T in this situation thinking that you're giving the buyer the solution they need. Because remember what a 22T does, it allows a buyer to terminate if there are conditions on title to which buyer objects. It does not give the buyer the right to terminate if there's something missing from title that buyer wants to have there. In this case, buyer wants to find a view easement recorded against title of property. If there is no view easement recorded, 22T does not give this buyer the right to terminate. For buyer to have the right to terminate in this situation, you're either going to have to write something specific that gives buyer the right to terminate following buyer's review of the view easement, or your buyer is going to have to rely on the time period provided by maybe an inspection contingency or a feasibility study where the buyer could use that time to lay their hands on the view easement, and if it's not satisfactory, terminate based on the inspection contingency or the feasibility study. You're going to have to keep a close eye on timelines in that case, because seller may not be required to provide a copy of the view easement unless you obligate them to do so by the language that you create in the contract. So beware of that if you are relying on the boilerplate inspection or feasibility. If you have questions on this form or any other, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtors member.